At this time, I'll call this meeting to order. Please join me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Ms. Secretary, may we have a roll call?
Sure. Commissioner Kirpies?
Present.
Commissioner Bergstein?
Here.
Commissioner O'Keefe? Here. Commissioner Maggio? Here. Commissioner Topchian?
Here.
Vice Chair Gregor?
Here.
Chair Charity?
Here. Thank you. Moving on from item 3 to item 4, approval of the agenda. Commissioners, having reviewed tonight's agenda, do you have any changes to it or a motion to approve?
I move approval. Second.
Thank you very much. All those in favor say aye.
Aye.
Aye. Thank you. Moving on from item 4 to item 5, approval of the minutes of our last meeting in November. Commissioners, having reviewed those minutes, do you have any changes to the minutes or a motion to approve?
I have some changes, or one change. Unfortunately, I did not have my mic on when I was making the proposal, so it's missing a little bit. The motion made by Commissioner O'Keefe on the top of page 4 should start with to report on potential alternatives to the NOI. To report on potential alternatives to the NOI for determining a fair return. So it was to return with the item with additional information on NOI formats. So before the first part, I think. Return, for staff to return with the item with information on potential alternatives to the NOI. Specifically, it was what other cities were doing, and information on the NOI formula. So it would be between the words with and additional, it would add the phrase information on potential alternatives to the NOI.
Thanks. We'll make those changes for the secretary. As amended, commissioners, do you have any other further changes?
Move to approve as amended.
Thank you.
I'll abstain as well, Chair.
Thank you. I'll second that motion. All those in favor, say aye.
Aye.
Aye. We have 2 abstentions. Thank you. Moving on from item 5 to item 6, public comment. I do see we have one public comment this evening. Mr. Yuri Shamayev. Forgive me if I mispronounced your name. Just to let you know, it'll help us if you speak directly into the microphone. You'll have 5 minutes to speak, I believe.
5? Okay.
3 minutes to speak, thank you. And before you start speaking, please state your name and your city of residence.
Okay. My name is Yuri Shamayev. I'm a resident of West Hollywood, been a resident since 1995. Recently, I'm inquired into a little problem with the City Hall and rent stabilization, that nobody seems to know the ordinances in the City Hall, what they stand for, or what the actual number of them, and what falls onto their jurisdiction. I have spoken to different people there at the City Hall, and every time there's an issue, they either give misleading information, or they say, oh, there's no such ordinance on the book, and when you prove it to them, well, they say, oh, I haven't read that. Can you somehow address that issue within the city? Also, there's a complaint against the, what's her title? Hearing examiner that refused to acknowledge city ordinances in her decision-making process. She makes it more on the favor of the landlord versus the favor of the ordinances that the city has passed to make sure the tenants' rights are not violated. So did the City Hall as well. It took me almost 90 days to get my hearing date set before they even set it. For 90 days. Well, the City of West Hollywood ordinance states that I must do it within, 3 weeks to set the date, not 90 days. And then I had to wait another month and a half to actually have my hearing. Why is this going on? And somebody should take responsibility for it. And when I got to the meeting, well, it made me feel like the hearing examiner was very well known by the landlord, extremely well known. that he was comfortable enough to throw his business card in front of her and tell it publicly on the record, stating, oh yeah, we have done this before. Before you make a decision, call me. I make sure you are satisfied. And then all of a sudden, she's the only one that can make a decision, when I requested somebody else to do that when I heard about it, to exercise my right to have an independent third party to do the decision. How is that possible that the same exact person always does the decisions? How come we only have one person doing that? There's nobody oversight over her. We have to come in front of the commission paying more money to get our cases heard. How come we only have one person that listens and deals with this matter? Why don't we hire more people or a bigger law firm to actually will have proper representation, not just one where the landlords already know her personally? How come, what is the reason behind it? There should not be just one person that handles all the hearings within the city of West Hollywood. I would like the commission to take a look into it, because I'm bringing my case in front of you whenever it comes up at this point, because this should not happen. There's ordinances to protect everybody, and if the ordinance says one thing, she should follow it, and not go by, oh yeah, I believe it's not part of it. I don't feel like using this ordinance, because nowhere in the hearing document have I noticed once she mentioning the specific ordinance that I brought it up, specific ordinance number that I brought it up, that justified me doing what I did, what my rights are. Nowhere does it say that. She questions every single thing, every other one, but not that specific one. Thank you very much.
Thank you.
Sorry for going a little bit over.
Secretary, I don't believe we have any other further public comment? No. Thank you. We'll be moving on from item 6 to item 7, our Director Manager's report.
Good evening. A short report, just a review of the look-ahead schedule. The Commission has canceled the December 27th meeting for lack of quorum. So the meeting, after this meeting, the next meeting will be on January 10th. There is one appeal scheduled that evening. January 24th, there is no appeal at this time, and staff will look at bringing one of the discussion items forward, if possible, for the Commission that evening. We do have an appeal scheduled for February 14th, and no appeal on the 28th at this date. That's my report.
Thank you, Mr. Noonan. Commissioners, do you have any questions or comments?
I have a couple questions. Just in terms of the NOI discussion we had last time, that's something that's going to go in front of council at some point, right?
We heard from the Commission, and we'll look at bringing information and that piece back. Ultimately, that will go to the council as an amendment to the rent stabilization ordinance.
I think that we would like to have it back, if at all possible, have it back before it goes to council. Is it possible to bring it back on the January 10th?
I'm not certain that it would be possible on January 10th, only because that would mean that the item was being worked on over Christmas and the New Year. But it could possibly come back at the end of January. I don't want to make a promise. We do have some time before the notices on seismic retrofitting go out, and so that change to the specific aspect in the rent stabilization ordinance that would apply those recognitions for the seismic retrofitting work in the NOI formula, it's some time before we need to put that in place. We did have an intention of bringing that back to the Commission before it goes to the council.
Oh, okay, that was my,
And we
doesn't
will
matter to me
look
what day then.
at, we will look at working on that for the 24th. I just don't want to make a promise that we can't meet.
Yeah, no, it makes no difference to me what day it's brought back. I just would prefer it come back before it goes to the council, if at all possible. Also, not in your report, but one of the items I saw that's coming up in front of the Planning Commission is a zone text amendment regarding housing, specifically stating that leases after, I think, 2001 must offer a one-year lease rather than being moot on the issue and offering 3-month or 6-month, whatever. Is it possible to have the I know it won't have any effect in terms of the process and the timeline that through the planning process or changing the zone text amendment, but is it possible for that item to come and at least be presented and either someone from planning to come and present it to us, or just it be presented as an informational item from staff here?
Yeah, I'm happy to ask our planning office if they would bring that item to you.
Thank you.
Chair, a quick question. I believe the buyout agreements ordinance is set to hear by the city council on Monday, next Monday. Is that correct? Or it was changed?
It was already heard. It was heard on December 3rd.
Oh, so I was out of town. That's why. All right.
It's on second reading on the 17th.
Oh, the second reading on 17th. And the commissioners can go there, and can we
You can, so it's on consent
speak in the public
at this point.
comment?
So the city council's already passed it, so it's on consent. So what you can
Oh, it's a
do is,
consent, okay.
but you can put a card in during general public comment.
To speak in
and-
favor or against it? All
Of
right.
course, yes.
Got it. Thank you.
Commissioners, anything further for the director or manager?
Mr. Noonan, our second highest rated priority from 1819 is receive updates on state and federal affordable housing policies during annual legislative update. In years past, I know it's been a while, we used to have our one of our lobbyists would come down from Sacramento and do a really informative update on housing in the state of California. Would that be something that might be possible in the upcoming year?
It would be. Alternatively, I know that Hernan Molina has come, and I think that he's given a great presentation, so we could ask him to come back.
He's still our liaison, is that correct?
Yeah, he interfaces with the legislators with our legislative office in Sacramento. So I think that he would be happy to come. We'll check in with him on timing. Certainly, I think we would have to. It would most likely be at the end of the year after some actions have been taken.
Commissioners, anything further? Very well. We'll move on from item 7 to item 8, commission comments. Are there
Chair, just a quick one. We heard the constituents' comments sounded very upset, and I hope that staff, Manager Noonan, maybe we can look into that, because we don't know what the speakers talked about. Maybe it's a specific case or it's a general inquiry. So maybe your office could just look into that. Thank you.
Thank you, Commissioner Topchian. Anything further? I just wanted to give kudos to our mayor, John Duran, for a really fun annual Congress. I was able to deepen some relationships with the Transportation Commission and Planning Commission, and for all those attended, it was pretty unanimous. That was a really great time and very fun. So it was good to see many of you there, and good to see many of my fellow commissioners and advisory board members there. If nothing further.
There's an article that I asked to be included in our packets tonight. I think there's some copies for the public as well. It was from the Apartment Owners Association magazine called Finding Relief During Difficult Times. It's a local nonprofit that helps people to avoid eviction by giving them like a one-time grant to help with their rent. I did share this with members of our Human Services Commission. I know the city used to have a contract with National Council for Jewish Women. There was a one-time grant if you were facing eviction. I understand that's no longer in place. I think it's now being handled through Jewish Free Loan Association, but this would be an additional kind of tool in our tool belt, not specifically for this commission, but just for our residents at large who might be facing a difficult financial time, and if they can get a one-time grant to avoid eviction, that would always be a good thing. Thank you.
Thank you so much, Commissioner Burstein, for bringing that up. Anything further? No. Okay, at this time, we'll move on to our appeals from item 8 to item 9. We'll start with item 9A, Appeal D-4351, at the address 937 North Orange Grove, Avenue 4. This appeal was filed by Mr. Gonzalez, who is the tenant. Mr. Gonzalez, are you present this evening? Thank you. This appeal will be opposed by the property owner, Zamir Investments, LLC. Thank you, a representative is here. At this time, we'll have a staff report for this appeal.
Thank you. Ryan Gonzalez has lived in Unit 4 at 937 North Orange Grove in West Hollywood since March of 2005 at an initial rent of $1,350 per month. He filed an application for a determination of the maximum allowable rent and also to determine if the landlord had retained any rent in excess of the MAR. Staff recommends that the Commission affirm the hearing examiner's decision. There is substantial evidence supporting the decision that excess rent has not been retained, including that the unit has been re-registered and any overcharges have already been reimbursed to the tenant through a rent credit. There is also substantial evidence supporting the hearing examiner's conclusion that there is insufficient evidence in the record to determine the MAR. Thank you.
Thank you. Commissioner, questions for the
Yes,
staff?
I do have a question about, can you help me understand or walk me through? So the hearing examiner ultimately decided there wasn't enough evidence in the record to determine the maximum allowable rent. But it's my understanding the maximum allowable rent is the initial base plus whatever AGAs have been put on it since the beginning. Is that not correct?
I think you're correct if you're saying it's the AGAs that have been actually implemented by the landlord. So to the extent that the landlord has properly notified the tenant of a rent increase, then they're allowed to take that AGA, and that's what the hearing examiner didn't have any information about one way or the other.
And she based that decision because she didn't have any evidence to show that certain years it had been implemented, correct?
Right.
So wouldn't that just by default be not implemented? I mean,
That's an excellent question. I think the hearing examiner, you can't determine it one way or the other. So it would not be proper for the hearing examiner to say, no one has come forward with any information, therefore I'm going to say the MAR is the initial, still the initial rent, because it's possible there's evidence out there. But determining the MAR, it's different from an overcharge case, for example, where the tenant has to come forward with a burden, but the MAR is what it is. And so at any time, the landlord could apply for determination of the MAR and bring that evidence forward. So at this time, we don't know what the MAR is.
but didn't the tenant apply for a determination of the MAR?
Right, and
The
so
landlord was notified of that.
that's correct. But the
Failed
tenant
to-
didn't produce that evidence either. So the lack of evidence can't go toward one side or the other because the MAR has it is what it is. It's a specific number based on what was actually done. And so in order for that determination to be made, there has to be that evidence there one way or the other.
So I know we still have both sides to hear before we get into deliberations, but would it not be appropriate for the commission to, or is there something in our ordinance that would not allow the commission to determine that the landlord had an opportunity to supply that evidence, they failed to, and so they did not take the AGA that year?
It would not be legally supportable for the commission to do that. The commission, for a couple of reasons, the commission is not the fact finder here, and also that's not what the ordinance allows. I think we would be in a different setting. So why don't we hear from them and then we can kind of come back during your deliberations and I'll answer more questions if that's okay.
Thank you.
I had a question. For the issue of the garage storage with the $200 overcharge, I saw the hearing examiner determined that that was not included in the calculations for raising the rent every year. And I just want to be sure that on page 26, when we look at the current monthly rent and we're looking at the 30-day notice and change in terms of tenancy, we are to read that as that $200 storage is not in that $1,500 and change number. Is that correct?
Yes, it was not included in calculating the rent increase.
Yes, and never included in any of these, just to be sure.
Correct.
Thank you very much.
Yes.
Commissioners, any further question before we move on to the oral arguments? Very good. At this time, the parties have an opportunity to present oral argument to us. The first party will be the appealing party, Mr. Gonzalez. You have 5 total minutes to speak. However, I'll wait till you come forward so you hear this part. So, Mr. Gonzalez, you have 5 total minutes to speak.
Okay.
You are allowed to divide that time and split it to rebut the other party's 5 minutes. So if you want to split your time, for instance, if you'd like to speak 4 minutes first and 1 minute after, please let the secretary know so she can time you before you begin speaking. And I also just like you to know that this is an appeal, so we're not able to hear new evidence, as you know, only evidence that was on the record from the lower decision. At this time, just please state your name, speak directly into the microphone so we can hear you, and you can begin.
Ryan Gonzalez. And if I could split my time in half, that would be fine. So my main issue was the rent that I'm paying now is I was paying for the past 3 years $1,800, which is over the actual amount of the rent, which was $1,700 something. I originally went to file for a hearing because when I went to the city, they told me that my unit wasn't registered and that they owe me a lot of money because of it not being registered. And they asked me what it was, and I gave them all the information. So they were the ones who told me, it should be X amount of dollars roughly. So, but to have the hearing examiner determine that. The hearing examiner, there was evidence supported to show that I was paying the amount of $1,800, and it was overage charge. There was an overage because of that happened every year for the past 3 years. I also showed in the evidence, which I don't know why it wasn't accepted as evidence, but that there was no lease separate to the garage unit even being separate. That was originally part of my rent. So where it became a separate issue, I have no idea. And how then that get taken away from, being part of the rent and made something totally separate other than her stating that they tried to bill me separately. But even the management company themselves said that they have no separate lease for that like they normally would have in existence. So as far as I know, it's part of my, my same rent. It's always been part of the rent that I'm paying. Between me and the owner, there was no other issue in regards to that, only until now when they said that to save money, that they don't have to owe me that extra additional fee. So that's mainly the discrepancy that was there. There was never a discrepancy as to them not owing me money. They did pay me by letting me not have, a rental credit, I guess would be what they gave to me, but it wasn't a number that I thought was even sufficient or even fair or even the right amount based on what was said. Thank you.
Thank you. At this time, we'll have a representative from Zamir Investments come forward. So you'll have 5 total minutes to speak, a complete block of 5 minutes. Please state your name and your city of residence into the microphone and try to speak directly into the microphone so we can hear you. And as I said before, we can't consider new evidence.
Sure. Only 2 minutes and a half.
Sorry, so you will just have because you are the opposing party, you only have a 5-minute block.
Okay.
Yep.
Okay. My name is Fernando Revalo. I'm on behalf of Samir Investments LLC, and I reside in Los Angeles, California. So I got new evidence. I have all the rent increases that I actually submitted to the tenant, and also based on the garage, we also back in 2017 we filed an eviction, which we settled back in 2017, and he paid all the back rent plus a separate $200 for the garage, which also had the evidence with he sued me a cashier check for those amounts and one payment. Other than that, we are based only on the lease agreement. The garage is not attached to the lease agreement. That's all we have.
Thank you very much.
Question.
Oh, sure. We have a question from a commissioner.
Question real quick. So it's your claim that you did reimburse, you accepted $7,832 in overcharges, but that was credited back to the tenant?
Yes.
Correct. All right. Thank you.
Mr. Gonzalez, you have 2.5 minutes if you would like to speak further.
So I just would like to say that the garage, there were no payments. All the payments that I made were always one sum total. I never paid separately for a garage. I never read out different checks for a garage, acknowledging that at all. I never paid, when we had when they tried to evict me, they couldn't evict me, then the owners told them not to and stopped that whole process because their numbers were all wrong, everything that they had was wrong, so that's why the eviction didn't even begin to go through. And there's never been, everything was settled, and there was no issue back then either until they tried to make it, when we had the hearing, it was all of a sudden now their garage was a issue, a separate cause, so I guess that's it. Thank you, guys.
Just a
Mr.
couple of
Gonzalez,
questions,
some
Mr.
commissioners have
Gonzalez.
questions.
I just wanted to ask you, you're not, clearly, the evidence shows that your tenancy began in March of 2005, right? So at the time, you didn't have the use of the garage storage.
No, but it was on my lease that originally I didn't even have a parking spot. I was supposed to have a parking spot and a garage that came with the unit. So they prorated my rent to effectively not have that because there was someone else in it that they weren't able to get rid of at that time. But it was part of my lease to have that. So then when it was time to do so, it rolled into my rent. That's why I never had to sign another rental agreement or a different lease renting out that unit or that garage for any different, because it was originally supposed to be part of the original lease, and it was when we signed that, there's like a list of things to, refrigeration, items of input that was there that was presented, and one of those things was the garage and my parking spot, because it's all part of the unit.
I don't know if that was submitted to the hearing or not, but the lease that I have that was submitted, it doesn't reflect that information. So the information we have is that you moved in March of 2005, you didn't have the garage storage unit, and then the first usage was in November of 2015, which is 10 years later.
Right.
So the initial, by reviewing the documentation, my understanding, what I see is that the service was not included in the initial rent because we go based on what was provided on day one when the first rent was paid. If the service was not part of the rent, it's not a landlord-provided housing service.
The way that I was informed from the landlord was that the rent, so I moved in at $1,350 because that was the prorated amount from what the rent was supposed to be, because of lack of having all the things that were given to me. So one took like a year for the parking spot to become available, and then they increased my rent for $100, and then when the garage finally became available, for whatever reason it took so long, then they increased it by $200, but they never asked me to sign a new lease or anything additional to anything of that nature at all.
Okay, thank you.
Thank you.
I think we have a couple more questions.
Mr. Gonzalez, I think we have another question for you. Sorry.
That's okay.
Sure. Yes, parking spot and garage.
We may need your
You didn't have
microphone.
that list or submit it?
It was, I thought it was submitted. I submitted that. I think even the RPM management submitted that, even on the rental agreement, the re-registration form that we had to fill out, they even filled that spot in there out. So I don't know why. There's a lot of information that I don't know why it was not accepted into, that's why I filed the appeal, because there was a lot of inconsistencies and a lot of things that didn't make any sense to me, because it was the city of West Hollywood that told me to file it because of all the issues that were there and of the circumstances, and those were all the reasons that they wanted me to file for a hearing. So
can I just clarify, the parking storage, is that different from a parking spot, or is that the same thing? Meaning, did you have something different, meaning a storage unit?
there's there's a parking spot, literally a spot, and then behind that spot is a garage. That's a two-car garage, and that came with the unit as well.
And are you saying that you had both of those from the very beginning, or at some later time you added the storage in addition to the spot?
No, I had them from the beginning. It's just they had someone else using it, so not leased out or anything, but someone else was using it. So
And just to clarify, it means the spot and the storage, or just one?
at first it was both, and then the parking spot became available right away within the first year, and then the garage, it took obviously a lot longer, but that was originally something that was already guaranteed to me, because my unit is the biggest, is in the back, so it's all private and secluded. I have a different back than the rest of the building. So it's not your average unit. It's not like a normal unit that other tenants have. No one else has that type of a unit. So I have my own private entrance. No one else has it. It's a regular apartment building for them.
And
So
just for our clarification, when you say right away, how right away is right away?
right away for...
Like when you first occupied your tenancy, you were able to park on the first day?
No, I was not able to park on the first day. That was an issue. And then
How soon after?
within the year before I was able to park on there. But they prorated the rent, they said, as a
So they,
for the
okay,
inconvenience.
so
Yeah.
you had, so when we're reading your tenancy agreement, I'm just clarifying that the box is checked that you had a parking spot, and you didn't have their parking spot, but they prorated the rent because of that.
Yes.
But the storage unit was separate from the beginning. You did not have the storage from the beginning, just the spot.
No, it was supposed to be both things.
It was supposed to be both, but I'm just saying that from the beginning, there was a spot and no storage.
There was no spot and there was no storage, and they
Then the spot came quick, but it was
yeah.
prorated, but I understand. I think, if commissioners, I think you, maybe if you have some other further questions, I get it.
So the rent initially on the agreement was $13.50. You're saying it was prorated to under $13.50 initially till
No,
the spot was?
it was prorated to $13.50.
Okay. You mentioned the checked boxes. As my fellow commissioner said, the assigned box is checked, and there's 3 boxes under it, one of which is security garage, and it's unchecked. That's the only document that I could find in the packet was the re-registration form, and the only one that was checked was assigned.
Was assigned.
The assigned parking, not
Assigned
the
parking,
covered garage.
I mean, the original that I submitted they were all checked, so I don't know. And it was a carbon copy that was submitted, so I don't know how well that photocopy is.
In our record, it says that you began paying the $200 a month, and I think it was 2015, was it?
I think so, yes.
That's right, you don't dispute that, and that was part of the
No, yeah,
record,
I
right?
increased the rent, and I've always paid more than the actual rent. It was just, when it finally became available, then they discussed, those numbers had been discussed prior to this even happening years before, so it wasn't like this was a new inquiry for me to, can I get the garage now that it's available? No, it wasn't like that. It was just, it's available now, here it is. It wasn't a separate inquiry, it was already a given.
Thank you.
All right, thank you.
I do have a question. So I know we've kind of discussed this over and over, but just so I can understand. So you're saying that $13.50 was the prorated amount for your apartment, the parking spot, but you didn't have yet, and the storage, but you didn't have yet.
Right.
Then the apartment or the parking was added for $100, and then the storage was added at a later date, much later date, for $200. So we've got $300 plus the $13.50, right?
Yes.
Is it your argument that they, over the years, when they increased your rent, also increased the rent on that $300?
I'm not aware of what they did in that respect at all.
The record shows that they
management
didn't.
company
I just,
It was the owner before. The management company is fairly new into the picture. So
but
they,
my question to you though is that your claim? Because the evidence that we have shows that they did not increase the rent on that $200 for the storage.
you're
But
talking
it-
about the yearly increase that they did?
Mm-hmm.
Yeah, I'm not aware that they increased on those things. I know they did on the car, the car aspect, I'm sure they did on that, so.
Okay.
But
So
the-
questionable on the 100,
I
but
don't-
you don't think so? You're not making any other different claim on the 200?
That's what I wanted them to look into, because I
Okay.
don't agree with any of the numbers that were stated there. The amount that they had credited me as the $7,000 some odd dollars was not a number that made any sense at all. It wasn't even based on them accounting to effectively all the late fees that I had paid, which were like sometimes $75
I understand.
and all that stuff. They didn't-
So because it's not your time to testify, I have to cut you short just to answer my questions. So, and that was my last question, is the $7,832 in credits, were you aware of the landlord giving you a credit? I don't know if, not necessarily the $7,832, but were you aware that you were getting a credit towards the end there for a certain amount that you'd overpaid?
They said that they will, I wasn't aware that I was going to get the credit. I was aware that we were going to have the hearing, and then based on what was decided, then we would go from there, and that was going to be the issue. So, and then if I had to pay what I had to pay, then we would decide.
I guess my question is, did you receive any credits, regardless of what they were for?
I haven't received anything yet. No, they have not ever handed me or written anything to me saying this is your credit to you.
Okay, thank you.
Sir? Sir? Sorry, not quite. So here are my concerns with your discussions tonight. Is you're saying that the rent was $13.50, which was prorated lower because there was no parking space, yet the lease that we have
Commissioner Burson, I'm going to interrupt you
Sure.
for a second. If this is for your time for deliberation, if you have a question, otherwise I would encourage you to deliberate. Use those thoughts to deliberate.
I'll hold that for deliberation then. Thank you.
No further questions? Okay, thank you, Mr. Gonzalez, very much. Thank you very much. At this time, we'll move on to commissioner deliberation on this first appeal.
Do you want to go first, Rob? Commissioner Bergstein?
Thank you for clearing that for me, Ms. Attorney. So my concerns with the discussion tonight was the lease that we have in our packet, which is the only documentation we have to use going forward, shows the initial rent was $13.50 and included a parking space. It doesn't say $13.50 no parking space. There's no addendum going when a parking space becomes available, the rent will go up. There's no mention of a storage unit. So I have a difficult time while the tenant says that, you know, it was supposed to be. I can't rule on supposed to be. I have to base my decision ruling on what's in the record, and the record for me is very clear, showing there was a parking space included. That was the rent initially. A number of years later on, that storage space garage became available. That was offered to the tenant and an additional fee. I know the tenant was been saying that, you know, I paid $1,800 a month. I think it's merely that it was for convenience of both the tenant and the property owner that one check was accepted for both the garage storage space and the rental of the apartment. You know, the landlord could have insisted on separate checks if they wanted to for record keeping, but just one check was accepted. So for me, the record's relatively clear of what the initial rent was, that it included that parking space. It did not include the additional garage that came much later date, and that additional charge of the garage was never calculated in for any annual adjustments in the rent.
Thank you, Chair. Well, when it comes to the reduction of housing services, the concept usually is whether the service was included in the initial rent when the tenant moved into the unit. And by reviewing the documentation before us and the rental agreement clearly, which is, in this case, we were lucky to have a fully executed rental agreement that sets the terms and the conditions. And that rental agreement does not include parking storage unit or space. So therefore, the initial rent that was that's included in the rental agreement, $13.50, in my opinion, does not include the parking or garage storage space. It was later provided. For the usage was established later in November of 2015, 10 years after. So by having this full executed rental agreement, you cannot really make another kind of a assertion, because we have the document clearly states that the testimony that there was another document, but it's not submitted, it's not included into this packet, and there was a statement based on the analysis provided by procedure background shows there was a statement that was discussed, but there is no document to support that tenant's assertion. So I agree with the findings on the MAR issue as well. So to me, everything is clear here, and I don't believe that the examiner erred in her decision. So I'm going to support staff's recommendation in this case. Thank you.
I too agree with the hearing examiner's decision in terms of there not being an overcharge of rent. I have questions, as you saw earlier, about the inability to determine the MAR, but I think what's most relevant this evening is the overpayment in that question. So I agree with her in that, and the reason I agree with her in that is because there's no disagreement that the rent started at $13.50. There seems to be no disagreement that to add on the storage was $200. There seems to be no evidence to support that of that $200 portion that it was ever increased by the AGA each year. In fact, there's evidence to show that it was not. So whether it was a situation where it was agreed upon at the beginning of the tenancy that the rent would be prorated and this would come later for an additional charge, or whether it's what the landlord says is that it was a separate side deal, it doesn't change the end result in this case because it was never increased. In fact, it's to the tenant's benefit that it has been treated as a separate entity, because if it were a prorated rent in the very beginning for the storage, then they could have, the landlord would have had the right to increase the entire amount, including that $200 by the AGA each year. But that's not what happened. So regardless of how you want to word it, for the tenant was not harmed in whichever path was taken. And it's to the tenant's benefit that it was handled the way it was handled. In regards to the overpayment of rent, there's evidence to show that $7,832 was collected in overpayment by the landlord, and the landlord willingly gave it back upon the re-registration of the form in 2015, I believe. Actually, I don't know when the credit was given back, but there seems to be no dispute about the amount of the credit in the record, and it looks, based upon the hearing examiner's determination and her calculations, that it had been returned. So the tenant was made whole by the time of coming to this hearing, or coming to the hearing in front of the hearing examiner. So those are the reasons for which I am going to support the hearing examiner's decision to uphold, or I'm going to support the hearing examiner's decision.
The three commissioners that went before me have basically said everything I would have said, so I won't take up a lot of time speaking. I would just point out that the law basically says we're supposed to defer to the factual findings of the hearing examiner, and the hearing examiner did in fact find that the $200 was separate from the rent. So unless that was clearly an error, we really shouldn't disturb that finding. So I too would support affirming the hearing examiner's decision.
I don't have much to add. I concur. I might want to have a different discussion about the MAR, but on the issue of the repayment of the overcharges and the garage space being separate, concur with what my other commissioners have said.
Yeah, I'm in an agreement too. I don't want to be redundant. I tried to pick it apart and find something, but just with the record, I couldn't find any reason to not agree with the hearing examiner's decision. If there's no more to say, would you do anything, Commissioner Maggio?
Except I'm in agreement as well with the hearing examiner's decision.
Thank you. Would anyone like to make a motion?
I'll be happy to make a motion. We have before us a draft resolution that reflects staff's recommendation to us this evening. Therefore, I will move Resolution RSC 18-538, a resolution of the Rent Stabilization Commission of the City of West Hollywood affirming the hearing examiner's decision on D-4351 involving 937 North Orange Grove Avenue.
Commissioners, do we have a second?
Sorry. I just wanted to ask a question. Is it now I can ask a question to staff or after a second?
Well, we do have a motion on the table, so we should deal with that motion. Thank you.
I'm going to second the motion.
Thank you. And at this time, we probably should have a vote, call the vote.
I have a discussion.
I have a further question.
Sure, thank
Just
you.
a clarification, maybe for the legal counsel. Because the tenant mentioned about the document that exists, in my mind, clearly the $200 is outside of the rental agreement. It's separate charge, $13.50, did not include parking, garage, etc. So now that document is, when we vote on this and whatever the outcome will be, can the tenant ever present it and file a new complaint or bring it up? And what if that changes the whole thing? I just, it struck me.
No, this was his opportunity.
Okay. Thank you.
Sorry to rush you, Commissioner Topshian. So at this time, Secretary Brino, may we call the vote?
Commissioner Kerpes? Commissioner Bergstein?
Aye.
Commissioner O'Keefe? Aye. Commissioner Maggio?
Aye.
Commissioner Topchian?
Aye.
Vice Chair Gregor?
Aye.
Chair Charity.
Aye. Thank you. The motion passes. Parties, if you have any further questions, please refer those to staff. And we will now move on from 9A to 9B, our second appeal this evening, D-4342. The address is 1241 North Harper Avenue, Unit 6. This appeal was filed by Ms. Haim. Is that correct? Ms. Haim, are you present? Thank you. And this appeal would be opposed by the property owner, Mr. Bertrand. Mr. Bertrand, are you present? Thank you very much. Ms. Haim, we're going to have a report from the staff just before the oral arguments, just so you know. Just not right now. We'll call you to speak in a moment. At this time, we'll have a report on this appeal from the staff.
Thank you. The hearing examiner in this case denied a rent reduction to the tenant for an issue involving the carpet. The tenant has appealed and argues that the landlord must remove the carpet and instead refinish the hardwood floors. Staff recommends that the commission affirm the hearing examiner's decision. In this case, the landlord had provided carpet throughout the apartment. The record shows that the carpet has been replaced within the last 7 years, and that is consistent with the RSO's maintenance requirements. Because of that substantial evidence supporting the hearing examiner's conclusion, denying a rent reduction for the carpet, staff recommends that the commission affirm it. Thank you very much.
Thank you. Questions for staff?
Yeah, just a couple questions. I see here in the record that there was a request for reasonable accommodation that was addressed to the landlord. What role does the city play in those sorts of requests and disputes?
None at all. That was a separate mediation nonprofit that was doing that.
Thank you.
I had a similar question, and kind of a broad question, if you can address it. For an ADA reasonable accommodation to add a housing service, my understanding that would not come before this commission. It would only come before the commission if it was a reasonable accommodation that was removed as a housing service. Would that be a...
Correct, for this type of a process, right.
Thank you.
Any further questions, commissioners? Very well. At this time, Ms. Haim, you can come forward. This is time for oral argument. So, as I stated earlier, you have 5 total minutes to speak. Because you are the appealing party, you can divide that time into 2 separate time periods, so you'll be able to let them know. Please speak directly into the mic, and when you're ready, please state your name and your city.
My name is Liza Haim, and I live at 1241 North Harper Avenue, apartment 6, West Hollywood. I live in this apartment for 30 years. I'm back and forth sending a letter to my landlord to paint my apartment and to do some stuff in my apartment, and I get all ignored. I didn't came to City of West Hollywood to get any increased rent issue. I didn't ask for anything. I just asked to send a letter so I can get, they can help me to do the job. And then my husband got sick, and I asked to take the carpet out. And he signed the carpet, but he didn't sign in 2017. He signed when I was in a hearing. So after the hearing, I told him I will do everything. I fixed everything. Just let me fix the floor, because if you take the carpet out, I don't know what's going to happen underneath of the carpet after 30 years. So if he let me to fix the floor and my own cost, nothing cost to him. He said no. And I sent him a letter, and I'm trying to avoid this appeal so he can accommodate me to do this, whatever cosmetic I need to do in the floor. And he said, no. Everything is no, so I don't know what to do anymore. I just asking, is this discrimination? Because most of the building has wood floor in the building, except me, and everything I try to do, everything is no, 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 and I don't know what to do anymore. That's, So he did sign for the carpet to take out, but I want to make sure if he's taking the carpet out, if there's any cosmetic things I need to fix, if I am allowed. He said, don't touch the floor. How I can not touch the floor if there's 30 years, if there's a plywood? The first owner told me she thinks there's a plywood underneath, and I was scared to take the carpet out because I didn't know how to behave with him because he didn't give me an option what to do with the floor. So I asked him, I will paint my whole apartment, I change my stove, I'll do everything in my own cost, just let me fix whatever I need to fix. And he said no, so I don't know what to do anymore. Maybe you can help me. Thank you for coming.
And please stay. We have some questions.
Yeah.
The carpet was in your apartment, it was removed, and he replaced the carpet, correct?
Yes.
But your request is that it be removed and that you're able to, at your expense, take care of whatever needs to be done.
Whatever needs to be done, it's at my expense to take the carpet out, to fix the floor, to paint my apartment, to do everything. I'm not asking for anything from him, but he said no.
Understood.
And he said, put vinyl, or don't touch the floor, or answer like that. He never give me a right answer every time I
Okay.
send him a letter.
Thank you.
So,
Thank you. I don't mean to cut you off, but thank you.
A quick question, are you on the first floor, right? Or
Huh?
what floor you live in? Are you on the first floor?
fourth floor.
Fourth floor. And you had the carpet from day one?
Yes, I have a carpet, I have vinyl, but you know
Okay.
the problem with the vinyl and the carpet is when you take the carpet, the vinyl is not gonna be not the same, so I
Right,
try
I just
to.
wonder if you had the carpet from day one. And you understood the reason why the examiner didn't rule in your favor in the initial hearing, right?
Because he agreed to take the carpet in my cost. He said it's okay to take the carpet, but don't touch the floor. So, but I have no option. I cannot take the carpet and leave like that.
Okay.
And he cannot just tell me, put a mat yoga on the floor and leave like that, or don't touch the floor. This is not an answer. I need an answer, what to do with the floor after I remove the carpet, if something wrong in the wood floor.
All right.
I know there's a wood floor underneath, but I don't
Okay.
know what the
Thank you.
situation with
Thank you,
that.
Ms. Haim.
So, Ms. Heim, in our record, we have an agreement from September 2017, which it seems like you guys came to some agreement to work with this floor at the cost. And basically, I see that your property owner signed it, and there's item 3. This is page 70, Commissioners, by the way. And it says, you agree to not replace any existing hardwood flooring located underneath the existing carpeting. So I guess my understanding here is that, is it your desire to take the carpeting up and replace the flooring, or are you just trying to refinish the flooring, or just?
I just want, if it's possible and the floor is not doing good, I can sand the floor. Instead, I'm not going to put any wood floor, and I told them that. I'm not going to put any wood floor on underneath if I remove the carpet, no. I know there's a wood floor underneath, but I don't know what situation they are, if they are good or not. If they're good, I'm not gonna touch it. If it's bad, I have to fix it. That's it.
So I guess my question is that it seems like you came to that agreement in September 2017, that that they signed off on this agreement that said that you could replace this, that you could pull up the carpet, at your cost, and you had agreed not to replace it, which you're saying here that you don't want to replace it, you just want to refinish it or make it as good as possible. So I guess my question is, how come we're here? How come that wasn't done?
I didn't understand the question.
Well, I see an agreement already that it seems like both of you came to some agreement on this floor back in 2017, that you were, allowed to make a reasonable modification to this, that you agree not to replace any existing hardwood floor located underneath the existing carpeting. You agree to properly dispose of the existing carpeting in the area located away from the premises. I just see an agreement that you guys came to at some point, so I'm wondering how come we're here, how come that wasn't done?
Because my husband is very sick, I have to take this carpet out, but I was afraid to take the carpet out without his permission to what to do with the floor. He said not to put wood floor. He doesn't want me to put the wood floor. There's a wood floor underneath, but I don't know how it looks like, the wood floor underneath. That's what I'm saying. Maybe it's good. Maybe I'm just gonna take the carpet and I don't have to touch it. But I don't know what to do with that. And
think the
need
commissioners
help.
can see my
That's why
confusion. I think
I
they-
didn't came.
Okay, well, that's all I can get. Thank you, we can move on. So at this time, we'll move on, if there's no other further questions, commissioners, we'll move on to the opposing party. Mr. Bertrand? So as I stated earlier, you'll have a 5-minute block to speak uninterrupted. Please state your name and city of residence into the mic.
Hal Bertrand, I reside in Los Angeles, California. Yes, we came to an agreement which I signed, and then on page 64 in the pamphlet that you guys gave me and the commissioners gave me, she tried to modify it, which I would not sign. In 2017, she gave hardwood floor sample to my brother who manages the building, and she asked if I would split the cost to redo the whole unit in a hardwood floor, and I said no. Then she brought a letter that her husband had asthma, and she needed the carpet taken out, and she went to Housing Rights Services. I went back and forth with them. I signed a reasonable modification, and the carpet's still sitting there for 1 year. I can tell the commissioner, I have asthma. If I couldn't breathe and I was sick, that carpet would not be there for 1 year. That carpet would be out. She just wants hardwood floors. The carpets were replaced in 12/14. When we replaced the carpet, she didn't like the carpet that we brought, so we allowed her to go to the store and get a different remnant and put it in. Basically, she said I didn't sign the accommodation except when we were in the hearing last time. That's not true. I signed it in the pamphlet. There's a thank you from Housing Services. This is all about her wanting the hardwood floor. She wants to take out the vinyl. She wants to rip up the carpet and put in the hardwood floor. And I said no. So that's all. Thank you.
Question. Sir, have you inspected that floor? Do you know if there is a decent floor under there that
I do
doesn't?
not. I do not.
And it's the only apartment in the building that has carpet?
Oh, no. Many units have carpet. Many have hardwood. The building originally was hardwood floor. And over the years, before I owned the building, I guess in the 70s, hardwood wasn't as fashionable. So when there was breaks in the hardwood floor, they would drop planks to repair it so it would be smooth. I don't know what's under there. But some units, it's mix and match.
So it could be in perfect condition,
Yes.
for that matter.
Correct.
All right, thank you very much.
Thank you.
Commissioners, anything further? No. Thank you.
Thank you.
At this time, we'll move on to deliberation on 9B.
I think that the hearing commissioner's decision was well-reasoned. The dispute is not something that's within our domain. Our domain is the rent stabilization ordinance, and it says that a housing service cannot be removed if it was either in the initial re-registration form or if it was subsequently provided. There was never a housing service provided that was not carpet. So I see that the tenant found assistance, she got an agreement signed, any issue for reasonable accommodation for disabilities is not within our domain, so this simply is not something that's within our domain, and I think the other parts of the decision were not disputed.
Well, I agree with what the commissioner said, and I just want to add that I believe that the tenant did not fully, clearly understand the process for the, in this case, a reduction of services issue, and filed the appeal with the file the application or the appeal with the with our commissions. The thing is, this issue is clearly outside the scope of the RSO in our jurisdiction. It's a reasonable accommodation matter, properly addressed by with the Housing Rights Center. And I'm reading the letter from the Housing Rights Center, which says as if the reasonable modification request is not granted or do not hear from you by the above date, and this is from November of 2017. The other option would be for the tenant to contact the California Department of Fair Employment and Housing. So maybe that agency may help to find the solution. So, but this is clearly, it's not within our jurisdiction, and although we understand maybe the need and necessity to replace that carpet by a hardwood floor, or maybe a laminated floor could be another option, but we cannot mandate the owner to do that. And with that, I will say that I wish the landlord would have cooperated, and maybe I wish the landlord would have found some sort of a solution that would accommodate you. We definitely wanted to see that. Hopefully that may happen in the future, but we as this body cannot really address that, and that's why I see that the examiner's findings are correct, and that's why I will support the staff's recommendation. But I hope that you will be able to resolve this matter. I really wish that will happen, because a lot of tenants in the city everywhere now are getting the carpets replaced. It's an ordinary thing to have a laminated floor or a hardwood floor. I hope that will be resolved. Thank you.
Yes, I would actually completely agree with what my fellow commissioner just mentioned. I think that it's not that I don't think you were necessarily confused about this process. I think that you were acting out of desperation and seeking assistance, and this was the tool most available that you thought you could use to move your efforts forward. Unfortunately, this is not the right forum to do this in, and you should contact the California Department of Fair Employment and Housing. I think in the situation that you discussed, where you're willing to take out the carpet, you're willing to make the repairs, you're basically just not wanting to do anything that upsets your landlord, but you're willing to cover all the expenses, is an ideal case for for a request for reasonable accommodation or modification. And I would like to see the landlord, I don't know all the facts, and I'll say that right now, I only know what's here in front of us, but I would very much like to see the landlord be a little bit more cooperative in helping you through this process. But again, I agree with my fellow commissioners that this is not the forum for us to be able to do anything, and I do agree with the hearing examiner's decision as well.
I would concur with my fellow commissioners and affirm the hearing examiner's decision. This is not a case where there was an existing housing service that was removed by the landlord and you asking to have that housing service that was in place originally either restored or reduction in rent. This is a request for an entirely new housing service. So unfortunately, that doesn't fall under our ordinance, nor does an ADA reasonable accommodation. So while I hear the frustration that your partner has allergies and asthma, and removing the carpeting might help with the health issues, as my fellow commissioner said, this is not the proper forum for that kind of determination. So I would be in favor of upholding the hearing examiner's decision.
I'm not sure I agree with all of my fellow commissioners' comments. Unless I'm misunderstanding this, the landlord has agreed that she can remove the carpet for health purposes. I don't think this is an ADA issue or anything, but that's beside the point. I agree with my fellow commissioners that the hearing examiner's decision is supported by substantial evidence in the record. Therefore, I would join my fellow commissioners in affirming the hearing examiner's decision.
And I'm also in agreement in affirming the decision. I feel like it's just a matter of you're allowed to repair but not replace, and you can get rid of that carpet, and it seems as though you could go forward and agree on that, and that gets rid of the carpet. So at this time, can we have a motion?
I can make a motion, Chair, to adopt a resolution of the Rent Stabilization Commission of the City of West Hollywood affirming the hearing examiner's decision on application D-4342 pertains to 1241 North Harper, unit number 6.
And I'll second that. So Secretary Brino, at this time, may we have a call for that vote?
Commissioner Kirpies?
Aye.
Commissioner Bergstein?
Aye.
Commissioner O'Keefe?
Aye.
Commissioner Maggio?
Aye.
Commissioner Topchian?
Aye.
Vice Chair Gregor?
Aye.
Chair Charity.
Aye. So thank you very much for appearing tonight, parties. This is a time for healing now. We've had the appeal. I hope everybody can return and try to find some middle ground with these issues. It's always best to just find some middle ground here on these issues. If you have any questions, please do come to the staff, and they'll be more than happy to assist you. At this time, we're moving on from our appeals, item 9 to item 10, new business, security deposit interest rate, and that will be a report from Mr. Noonan, I believe.
Thank you. So each year, the security deposit interest rate is announced. This year, we are a little late in announcing the security deposit interest rate. However, it is still applicable, and we need to do it. It's necessary. The interest rate is based on the banks within West Hollywood and the interests that are provided on their passport savings accounts. That interest rate is averaged, and then the interest rate is produced. It is 0%, and that's just an attribute and a fact because the banks are not paying much on savings accounts. So the commissioners that have been here at the commission for a while may note that it has been 0% for at least 5 years. And that's just, it's not an aspect in the code itself, it is an aspect in the reality that savings accounts aren't earning interest.
Commissioners, any questions?
No.
Or comments?
Question. So this is based upon our code, so I know that there's nothing we can do about it this year, and I wish I would have brought it up sooner, but now that, 1984 might have been a little bit different, but today we oftentimes do savings accounts online, and I know none of my banks are located here in West Hollywood or even Los Angeles. They're all credit unions or nationwide banks that I just deal with online. I would like to see, and maybe this is more of a motion or however we could do this before next year, if we could look at maybe revising our code so that it is more realistic in today's times. I don't know if the landlords now stick their deposits in Bank of America, or Wells Fargo here. If they were smart, they would just invest them online and put them in savings accounts where they actually do earn interest. And I'm looking just here at nationwide for bank accounts that don't require any minimums, don't require any automatic deposits. You can get up to 2% interest. And that's just a matter of doing it online versus walking into your bank here in West Hollywood. So in the future, I know we can't do anything this year, but I'd like to see us review the ordinance to make it more flexible to where we can look at percentages based upon what real options landlords have.
Thank you. Commissioners, any further comment or question?
I have a question. Since we're moving away from sending out paper notices, we're moving more to online notification. How are we notifying both landlords and tenants of the upcoming year about the zero interest on security deposits?
So it's in the newsletter that comes out in January of each year, and that's not changing. So that is how we've always notified landlords and tenants of the interest rate, and it's how we will continue. And it's a paper newsletter.
If that's all, we're ready to move on. So we'll be moving on from item 10, new business, to item 11, ad hoc subcommittee update on unit re-registration.
You have to approve that or anything, just procedurally?
It's just a receive and file.
Oh, okay.
Thank you. Sorry. Ad hoc subcommittee, do you have a report?
We do,
Thank
yes.
you.
Okay, I just wanted to add for the record that I joined not officially or unofficially, I joined the ad hoc committee, so I was there present. And maybe you could count on me again. Just let me know.
You can correct us if we're wrong on our report. So tonight was our third actual meeting, second with staff. We basically have concluded what our purpose or what our mission was for the ad hoc committee, although we will be back at the next meeting or at a future meeting with the actual written proposal. We basically looked at two elements of the re-registration form. And I'll talk about one, and then Commissioner O'Keefe will talk about the other. The first was about the compliance, basically in a situation where the landlord, there was compliance, but there was maybe unintentional either misfiling or not filing of the form. But the tenant was fully aware, both signed the registration form, the landlord and the tenant. The AGA was followed strictly according to the law, and the term, or basically the form just wasn't found with the city, whether it was lost, not filed, whatever the situation might be. And that's what we'll be bringing back a proposal for, and we will talk about the specifics and how often that's happened in the past, all that in the written report. And then we also talked about another aspect of re-registration, which Commissioner O'Keefe will talk about.
Sure. So this was the issue of trying to consider options for incentivizing landlords that had units that were not currently re-registered to re-register once the electronic filing was in place. Possibly either waiving the overpayment charges in the past or limiting the time to which overpayments could be accrued if once the electronic filing was available, they registered within a short amount of time. However, there was not majority/unanimity for that proposal, so we won't have a proposal going forward on that.
But those are the two areas of the re-registration process that we discussed. And, like I said, we'll bring a proposal back to you on the first one, probably at the next meeting or soon.
Thank you so much. Commissioners, any questions for our ad hoc subcommittee?
The instances, examples that you brought up, that this were the cases that we heard, right? Those two cases we had.
One of the recent cases, yeah, or one of the cases that we often talked about in our discussions was a recent case that we just had that was seemed like there was full compliance minus the form with the city.
Were there any other cases, if staff was able to find, locate any other instances of, similar?
Exactly like that one, no. But I believe there was one other case that the form was missing. And then I have to look through the numbers again. I'm hoping to be able to include that in our report, I'd say how often, but really how few times it's happened in the past.
Okay. Thank you.
Commissioners, anything further? Very good. Thank you very much for your report. At this time, we'll move on from item 11 to item 12, public comment.
Just a quick question before we do that, just because in our packet, I don't know if this was just for our information, but after the page on interest rates on security deposits, we have a document dated December 13th on 2019 RSO Building Blocks Educational Seminars with some information on the feedback received. Was this just for our information? No action
I'll touch
needed?
on that in my comments.
Okay.
Thank you so much, Commissioner Bergstein, for bringing that up. Secretary Brino, I don't believe we have any public comment at this time. No, thank you so much. Moving on from item 12 to item 13, commission comments.
Just wanted to say what a pleasure it was to serve with Commissioner Gregoire, and we're so sorry that you're leaving us and wish you all the best.
Well, I suppose I should announce for the public that yes, tonight will be my last meeting after 18 years on the Rent Stabilization Commission. It's been a pleasure and an honor to serve the city of West Hollywood and all the tenants who live here in this capacity. I can't believe it's been 18 years. I feel like I was appointed to the commission yesterday. Not sure what to say about it. It's been a very rewarding experience. The thing I thought was really cool about being a rent stabilization commissioner, that our primary duty is to sit as an appellate board. I'm a lawyer in my day job, and as a lawyer, I'm an advocate. I advocate for clients, and as a commission, we don't really advocate for either landlords or tenants. We're supposed to be neutral. And so it's been a lot of fun for 18 years to basically sit as a judge as opposed to an advocate. So I will miss that. You know, I thought I would go around the room and say something nice about everyone, but I won't bore everybody. You know, it's really been my pleasure to work with each and every one of you, staff and commissioners included. However, in particular, I can't go without joking about Commissioner Maggio and I have been sparring for many, many years about who is going to be the longest serving rent stabilization commissioner. And there was a point when, you know, there was a point when Commissioner Maggio was temporarily not on the commission. I thought, aha, I am going to serve longer than Richard Maggio. And then, of course, he was reappointed. And you know what? Richard has outlasted me. So Richard will have the honor of being the longest serving rent stabilization commissioner. But Richard, you know, it's been such a pleasure serving with you for 18 years. I've learned so much from you. I really treasure the friendship we have formed over all of these years. And we'll see how many more decades you can serve on the Rent Stabilization Commission. So yeah, it's been a lot of fun. Commissioner Topchin, I've served on the commission with for almost as many years as Commissioner Maggio, and Agassi is one of my dearest friends and always will be, and we'll certainly stay in touch. I asked Rob earlier, how long have we been on the commission together? He says it's not that many years, but it seems like most of the time you've been here. So, and Josh as well has been on the commission 2 or 3 times. So it's really been a pleasure serving with all of you. You have all brought unique perspectives to the commission that I've appreciated, even though we haven't always agreed on certain things. And you know, Garrett and Karen, you've been wonderful new additions to the commission, and you know, I hope you serve on the commission for many years to come. You have a lot to contribute to the commission and our community. And staff, you know, we have wonderful staff here at the City of West Hollywood, in particular in the Rent Stabilization Department. And it's been great working with Allison so many years. It's like, I don't know how many years we go back working together, but it's been a real pleasure. Thank you for all your legal guidance. And Peter, not as many years as Allison, but you know, it's been wonderful getting to know you and becoming friends, and thank you for everything you've done. And Celeste, welcome to the Rent Stabilization Commission. Thank you for your service as well. So I guess that's, and last but not least, I should thank City Council member John Heilman for appointing me 18 years ago and showing confidence in my abilities all of these years. You know, he's been terrific. You know, he's always let me do what I do. You know, he's never interfered with any decision that I've made. You know, he's never gives me input. He's just sat back, and you know, I guess I never screwed anything up because he let me serve as his commissioner for 18 years. So thank you, John Heilman. It's been an honor serving as your commissioner. So thank you so much.
I just wanted to thank you. I think the city's been most fortunate to have you serving for these past 18 years. While you and I haven't always agreed, you have a number of qualities and skills that I have always admired. And I think my top 2 are because of your length of service, you have heard most of the arguments over the years. And we always get a young hotshot attorney who's never been before our commission before that cites that we are in violation of the Petrus Act. And you always just very calmly said, you know, we've heard this argument before and have held in the court, very calmly and scholarly and legally help the attorney understand why that was not a valid argument every single time, and I appreciate that. And secondly, just importantly, what I have really appreciated is when there have been issues that members of the commission want to have further discussions on, even when you weren't in agreement with what we want to discuss. You said, my fellow commissioners ought to have the opportunity to discuss this further, have subcommittees, and I appreciate that. So again, I want to thank you for your many years of service to our tenants and landlords, and wish you well in life post-commission.
Rob kind of took the main thing that I was going to say. That yes, thank you for the years of service you've been here for. You've been a great example to me through all of the time that all the times that I've been appointed to the commission, and that's what I would say most is I always. No matter what, well, first of all, I always thought you'd agree with me, but you didn't necessarily always agree with me. But when you didn't, you were always open to discussion, and you were always supportive of having a discussion about the subject matter that you may already know that you're opposed to. And I really very much appreciated that. That means a lot, and I think that it's helped all of us on the commission realize that we can be opposed to something, or we can be for something, or have a position on something, but still be open to allowing our other colleagues to grow and to learn. I'm not going to be able to join you later tonight. I've been sick the last couple of days, if you couldn't tell by my taking little breaks to blow my nose and stuff like that. But I was thinking earlier, I wanted to give you just a few little gifts, and one of them is a little stress ball that this is for you. I know that you're not going to just go home and ignore us every week, so that you're going to be watching from home on Thursday nights, and with 18 years of experience, you're going to be needing that ball to just pay attention to what we're doing, and just take it out on the ball, and know that we'll correct ourselves someday if we do make a mistake. The other thing is we talk about you retiring from the commission. Well, we don't get paid on the commission. We do get a stipend, but I don't think there's any reserves set aside for you at all for a retirement fund or anything. So I got you this little, it's called a personal emergency oil reserve, and I thought about it later. Maybe by the time you need this, we won't need oil, so it won't be valuable at all, but oil still is valuable today, and it's, from what I understand, it's a fossil, and if you hold on to it, I think put pressure on it for like 50 million years, you'll have your own little oil reserve, and that's just for you. So it'll pay for your time in retirement. And so thank you again for everything, and hopefully you enjoy your oil and stress ball.
And David, it's been a pleasure. From the very beginning, you took time to get to know me, and we went to breakfast together when I joined the commission, and it was really nice, a nice introduction to this commission. And then over the time, it was really a nice experience for me to see how your mind works and how you're able to elucidate main points and keep us on track. And it was a very nice way that you have about keeping us on track with the commission. And then also, I really got to see firsthand how, at one point, if you recall, he drafted a motion freehand when we needed a motion drafted at the very last second, and he did it right on the spot that we were able to approve. So really a great attorney, a great guy, and I wish you great things in the future, and have a great 2019 traveling the world, and tell us stories. And you're my neighbor, so I'm sure I'll stop you and ask you how things are going.
David, it's really hard for me to say in few words what I feel about this moment. At this moment, we met 18 years ago. 12 years ago when I was appointed to this commission, and from day one, you became my really good, very good close friend and a mentor. And I've learned a lot from you, and I really thank you for that, for your guidance, for slowly kind of, bringing me into the loop of everything. You are a great lawyer, you're a great person, you're a dedicated servant for 18 years, serving the community, the city that you live in. It tells a lot about the person like you are. And by knowing you on a personal level as a friend, you're absolutely amazed me when, like a little thing, for example, I remember when we were talking about a parking permit use, like the people should not use the parking. Apparently, David, Commissioner Gregoire, never once used the parking permit, even for the commission-related meetings, because he finds that sort of like a privilege thing, and he would just basically refuse it. it is absolutely incredible what type of personality you are. And I admire you a lot, and you're just my good friend. I've learned a lot from you. I'm going to miss you here because you brought this completely different vision and approach and your style. Not always we agreed on issues, and you know that. We had some disagreements. But you always remained very balanced, and all you did is you basically ensured that the RSO is enforced and protected. And as someone who is I'm an advocate of the RSO, of course, and we all are. And I appreciate that you brought your legal experience and your background into this and part of your life, and you made it look really beautiful. And thank you so much for all you've done for the city. And of course, I want to thank Councilmember Heilman for appointing you, and who kept reappointing you to this position. Thank you, and you will be missed, really. But we will continue our regular breakfast or lunch, whatever we did.
Well, I guess I'm last. We've been talking about this for a couple years, and I didn't think it would really happen, but it did. I kind of have a couple new names for you, either Mr. Cool or Mr. Chill, because you really are always so calm in regard to everything that occurs here and has occurred here. You were extremely articulate and loquacious tonight, and I like that. I have to say, you've taught me a great deal. You taught me to understand my ordinances and regulations better than I started off doing. And 18 years is a long time. And I think the one thing that I always felt that was kind of unusual, and it isn't so unusual, that you're fluent in Russian. And I never thought this guy from New England would speak fluent Russian, and I'm surprised Agassi didn't. He forgot that. But we've had such a grand time, and we live in the same city, and we'll continue our friendship. There's no doubt about it. We already have proven that. And now we won't be complicated about going out to dinner and who could come. Now we can invite Garrett, because you won't be a commissioner, and enjoy the Russian food that we allow Agassi to always order and leave there. The vodka? No. Anyway, thank you. And my only request is, can we get a photograph, all the commissioners, before we all walk out tonight? Peter, I think, will accommodate us. Thank you.
Well, thank you all for your comments.
Thank you, commissioners. Do we have any further commission comments before moving on? No, thank you very much. At this time, we'll be moving from item 13 to item 14, staff comments.
I'll just briefly say thank you so much for your service, David. It's just been an absolute pleasure working with you over these years. You've certainly made my job so much easier having you on the commission, and you wear your appellate hat very well. You understand exactly what the role is, and I really appreciate how prepared you always are and dedicated, and it's just been great working with you, so thank you.
I agree entirely. It's been absolutely wonderful, and you will be missed on the commission, certainly. I'm not going to say goodbye, though, because we're going to stay in touch. So
Absolutely.
I'm looking forward to that. I will touch on this one slight point of business that we had in the packet. And it's just a mistake that we didn't have that on the agenda, so the commission didn't have a chance to chat about that item, but I'm happy to bring back the building blocks at the first meeting next year. We always like to report out at the end of the year on the attendance and the satisfaction surveys that we provided the building blocks. The one thing that I will point out that I think is wonderful is that we had a 50% increase in our attendance. And that was over 2017, and 2017 was an increase over the prior year. What we did in 2017 is that we changed the format from individual specific items that were offered throughout the year to focusing on a 101 and a 102, a basic and an advanced tenant workshop and a landlord workshop, and then offering them in the fall and in the early spring or late winter when most folks are not on vacation, they're not, kids are in school or what have you, so people are around, and I think that it's really paid off. We've had better attendance and more people coming to the events and learning about the RSO. That's all I have to say. Again, thank you, Commissioner Gregoire. It's been a real pleasure.
Manager Noonan, just a question about the building blocks, the training workshops. You're gonna this department is going to select the topics, or it's going to be general RSO basics, or each training workshop would be dedicated to a specific topic or subject?
Yeah, I think that we have the upcoming forms in your packet here.
Oh, I didn't see it, I'm
And
sorry.
these are the flyers. These are going to go out in the newsletter. On this one, the only difference, if you flip this around, there's Russian and Spanish on the back. So in the past, we have done separate flyers, and we haven't been able to provide it on a single flyer in the 3 different languages. And so we do have that now. You can see the listed items on the front. Of course, the back is more of a reduced version, but it does encourage people. It describes the events and then encourages them to give us a call. We do have folks at each event for translating in case someone needs the seminar translated into Russian or Spanish. The first one is basics of the RSO. The second one is more complicated, more complex aspects in the RSO.
Okay, yeah, I see it now. Thank you.
Just curious, the satisfaction seems to have gone down from the first group to the second group. I don't know if there was any feeling during the building blocks themselves that people were well receiving the information and happy with what was going on. It was just people who responded, the only ones who responded were not as happy, or if you noticed anything from the first set to the second set where people were less satisfied during the building blocks.
Part of it might be an aspect that we now have more people in the sessions.
Are there any further comments or questions for staff?
One final, just because hopefully you will always be with us for the remainder of your term, but in case you can't be at this meeting, we do need to elect a new vice chair. I would ask that we agendize an election after Councilmember Heilman has appointed, no one's going to ever replace you, Mr. Gregoire, but when that position is filled, that we agendize elections for vice chair.
Yes.
Thank you. So at this time, I believe we're ready to move to adjournment. Our next regular meeting of the Rent Stabilization Commission will be held on January 10th, 2018 in the West Hollywood Park Public Meeting Room in the council chambers. Please stick around for that picture, and this meeting is adjourned.